Don't sit there like you're in charge. This isn't your courtroom.
You are inside my home without a warrant. You are breaking federal law.
You think that title scares me? I don't care.
The dinner table was set for 4. Candles flickered against wine glasses. Laughter echoed through the dining room of the modest brick home on Sykenham Avenue. Judge Diane Forrester had just finished telling a story about her grandson's first day of kindergarten when the pounding started. Not knocking, pounding. The kind that makes your chest tighten and your hands freeze mid-gesture. 3 ICE agents were about to make the worst decision of their careers, and they had no idea that the woman reaching for her napkin held the power to dismantle everything they thought they knew about authority. The force of the banging rattled the front door in its frame. Judge Forrester's dinner guests, her sister Carolyn and 2 colleagues from the courthouse, went silent. The kind of silence where you can hear your own pulse. Another series of thunderous knocks shook the house. A voice boomed from outside. "Federal agents, open the door now." Judge Forrester stood slowly, her chair scraping against hardwood. She walked to the foyer with measured steps, her 23 years on the federal bench evident in her composure. Through the peephole, she saw 3 men in tactical vests with ice patches visible under the porch light. She opened the door partially, the chain lock still engaged. "Can I help you?" Her voice was calm, but carried weight. The lead agent, a man named Vincent Kozlowski, with 15 years in immigration enforcement, didn't answer her question. He demanded to know if Maria Sandoval was inside the residence. Judge Forrester asked who was asking and under what authority. Kozlowski's jaw tightened. He said they had information that an undocumented individual was inside and they were conducting an enforcement operation. Judge Forrester asked to see the warrant. That's when everything accelerated in the worst possible direction. Kozlowski said they didn't need a warrant for this type of operation. Judge Forrester, a federal judge who had presided over countless immigration cases, knew that was categorically false. She told them they absolutely needed a warrant to enter a private residence without consent. Kozlowski's face flushed. He said they had exigent circumstances. Judge Forrester asked him to articulate those circumstances. The agent behind Kozlowski, a younger officer named Troy Bannister, stepped forward and said they didn't have time for this. They had credible intelligence that their target was inside and fleeing. Judge Forrester looked past them. No one was fleeing. Her block was quiet. Porch lights glowed from neighboring homes. A cat wandered across a lawn 2 houses down. She told them again, clearly and slowly, that without a warrant, they could not enter. Kozlowski made a choice. He signaled to the third agent, Ramon Gutierrez, who moved toward the door. Judge Forrester attempted to close it, but Gutierrez wedged his boot in the gap. Kozlowski announced they were coming in under federal authority. Judge Forrester raised her voice for the first time, commanding them to stop, identifying herself as a federal judge and informing them they were violating the Fourth Amendment. Kozlowski laughed, actually laughed. He said if she was really a judge, she'd know they had authority here. The chain lock snapped. 3 agents pushed into Judge Forrester's home. Carolyn screamed from the dining room. The 2 courthouse colleagues stood frozen as armed men in tactical gear stormed through the foyer. Judge Forrester demanded they leave immediately. Kozlowski ignored her completely, directing Bannister to check upstairs and Gutierrez to clear the first floor. Judge Forrester followed Kozlowski, her voice sharp and steady despite the violation unfolding in real time. She repeated her identity. She demanded supervisor contact. She informed them every action was illegal. Kozlowski told her to step back or she'd be charged with obstruction. That's when he grabbed her arm. A federal judge, in her own home, during a private dinner, without a warrant, without cause, without even confirming her identity. Judge Forrester jerked her arm away and told him not to touch her. Kozlowski's hand went to his hip, resting on his service weapon. The implied threat was unmistakable. Bannister came downstairs announcing the second floor was clear. Gutierrez emerged from the kitchen shaking his head. No one matching their target description was present. Because Maria Sandoval wasn't there. Had never been there. The intelligence was wrong, outdated, or possibly fabricated. But instead of apologizing and leaving, Kozlowski demanded identification from everyone in the house. Judge Forrester's colleagues produced their credentials, both attorneys who worked in the federal courthouse. Carolyn showed her driver's license with shaking hands. Judge Forrester walked to the entryway table, retrieved her judicial identification, and held it directly in front of Kozlowski's face. The color drained from his features. His mouth opened slightly. No words came out. Bannister looked over his shoulder and muttered something that sounded like a prayer or a curse. Gutierrez took 2 steps backward. The atmosphere shifted instantly. Kozlowski's aggressive posture collapsed into something resembling panic. He stammered an attempted explanation, saying they were following up on solid intelligence, that this was a routine enforcement action, that there must have been some miscommunication. Judge Forrester cut him off. She informed him that he and his team had just committed multiple federal violations, including unlawful entry, assault on a federal officer, and civil rights violations. She told them to leave her home immediately and that she would be filing a formal complaint with their superiors at the Immigration and Customs Enforcement Office of Professional Responsibility before the night was over. Kozlowski tried to salvage the situation. He suggested they could all sit down and discuss this calmly, that perhaps there was a misunderstanding that could be resolved. Judge Forrester's response was ice. She told them the only thing they needed to understand was the location of her front door and how quickly they could walk through it. The 3 agents left, but the damage was done. The violation was complete. The consequences were now inevitable and unstoppable. The moment the door closed, Judge Forrester called the federal courthouse emergency line. She detailed everything in precise chronological order. The pounding on her door, the refusal to show a warrant, the forced entry, the physical contact, the implicit threat, the ransacking of her private residence, all of it captured in her methodical recounting. The duty officer on the line went silent for a long moment before asking her to repeat her name and title. When she did, the officer said he would escalate this immediately to the chief judge and the U.S. Marshal Service. Within 30 minutes, 3 separate entities had been notified: the chief judge of the Federal District Court, the U.S. Marshal Service, and the Department of Homeland Security Inspector General. By midnight, preliminary reports were being drafted. By morning, the story would break in ways that would genhan the entire federal law enforcement community. But Judge Forrester wasn't finished. She spent 2 hours that night documenting every detail while her memory was fresh. She noted the time of the initial pounding, the exact words spoken, the physical descriptions of each agent, the badge numbers she'd glimpsed, the sequence of their movements through her home. The location where Kozlowski had grabbed her arm, leaving a faint red mark, she photographed immediately. Her colleagues offered to stay, but she sent them home. Carolyn remained, sitting in the kitchen drinking tea that had gone cold, still shaking from watching armed agents invade her sister's home. Judge Forrester worked at her dining room table, the same table where 30 minutes earlier she'd been laughing about her grandson. The candles had burned down to stubs. The wine sat untouched. The meal was ruined. But the documentation was thorough, methodical, and devastating. What Kozlowski, Bannister, and Gutierrez didn't know as they drove away from Sycamore Avenue that night was that they hadn't just violated procedure. They hadn't simply made a mistake that would result in a reprimand or additional training. They had assaulted a federal judge in her home without legal authority, creating a constitutional crisis that would reverberate through multiple agencies and end careers in spectacular fashion. The intelligence they'd relied on? It would later be revealed as completely fabricated, based on an anonymous tip that was never verified, never corroborated, and should never have justified any action whatsoever. But that revelation was still hours away. For now, 3 ICE agents believed they'd simply had an unfortunate encounter that would blow over. They had no concept of what was coming. No understanding that by morning, their names would be on reports circulating through the highest levels of federal law enforcement. No idea that the woman whose arm Kozlowski had grabbed would become the catalyst for the most significant immigration enforcement scandal in recent history. Morning arrived with the force of a detonation. By 6 a.m., the Inspector General's emergency response team had assembled in a conference room 3 states away. By 7, the U.S. Marshal Service had agents en route to interview Judge Forrester. By 8, the Chief Judge had convened an emergency Judicial Council meeting, and by 9, Director Samuel Keaton of ICE was sitting in his office staring at a preliminary report that made his blood run cold. 3 agents, 1 federal judge, 0 legal justification. The mathematics of the disaster were brutally simple. Keaton had been with immigration enforcement for 23 years. He'd navigated budget crises, policy changes, administration transitions, and countless controversies. But this was different. This wasn't a policy disagreement or a political battle. This was armed federal agents forcing their way into a sitting judge's home based on intelligence so flimsy it wouldn't have justified a phone call, let alone a raid. He picked up his phone and made the call he'd been dreading. Within 90 seconds, he was connected to the Attorney General's office. The conversation lasted 4 minutes. Keaton did very little talking. Mostly, he listened as a voice explained in precise legal terms exactly how catastrophic this situation was and what would happen next. The agents were to be suspended immediately. Full investigation with outside oversight. Complete audit of the intelligence that led to the operation. Review of every case the 3 agents had worked in the past 2 years. And personal apologies from the highest levels of the department to Judge Forrester. That last part stuck in Keaton's throat. Not because he disagreed, but because he knew an apology would mean absolutely nothing at this point. You don't apologize your way out of constitutional violations. Across town, Kozlowski was eating breakfast when his phone rang. The voice on the other end told him to report to headquarters immediately and bring his badge and service weapon. No explanation, no discussion, just the order and a dial tone. Bannister got the same call while dropping his daughter at school. Gutierrez received hers in the middle of a workout at the gym. Within 2 hours, all 3 were sitting in separate interrogation rooms. The same kind they'd sat suspects in countless times before. The irony wasn't lost on anyone. The interviews were methodical and devastating. Each agent was walked through the previous night step by step. What intelligence had they received? A single anonymous tip called into a hotline. Had it been verified? No. Had they attempted to verify it? No. Had they obtained a warrant? No. Had they consulted with legal counsel before proceeding? No. Had they identified themselves properly at the door? Debatable. Had they forced entry after being denied? Yes. Had they made physical contact with the resident? Yes. The interviewer, a woman named Special Agent Victoria Raines from the Inspector General's office, had the kind of calm demeanor that made everything worse. She wasn't angry, she wasn't emotional. She simply documented each answer with the precision of someone building an airtight case. When Kozlowski tried to explain that the woman had been uncooperative, Raines stopped him mid-sentence. She slid a photograph across the table. It showed Judge Forrester in her judicial robes at a naturalization ceremony, swearing in new citizens. Kozlowski stared at it, his face draining of color as understanding finally crashed over him. Raines let the silence stretch. Then she asked if he'd bothered to run the address through any database before executing the operation. He hadn't. If he'd simply entered the street address into the federal property registry, it would have flagged immediately as a federal judge's residence, triggering automatic protocols that would have prevented everything that followed. But he hadn't checked. None of them had. They'd received a tip, made assumptions, and acted. Bannister's interview went similarly. Gutierrez's was worse because he'd been the one physically searching the home, rifling through personal belongings without legal authority. Raines asked him what he'd been looking for. He couldn't answer clearly because there had been no specific target, just a vague directive to find evidence of illegal presence. Evidence of illegal presence in the home of a woman born in Philadelphia who'd served as a federal prosecutor before being appointed to the bench. The absurdity would have been comedic if the consequences weren't so severe. By noon, all 3 agents were officially suspended without pay, pending the outcome of the investigation. Their credentials were confiscated, their access to systems revoked, their lockers cleared. 24 hours earlier, they'd been federal agents with authority and power. Now they were subjects of a criminal investigation, with lawyers telling them to remain silent. The media got wind of the story by early afternoon. The initial reports were careful, citing unnamed sources about an incident involving immigration enforcement and a federal official. But by evening, Judge Forrester's name was public. By the next morning, it was the lead story on every major news outlet. The details were explosive. Armed agents, no warrant, forced entry, physical contact. And the victim wasn't some random citizen, but a federal judge who dedicated her career to upholding the law they'd so spectacularly violated. Legal experts lined up to offer commentary, and their assessments were uniformly damning. Fourth Amendment violations, potential assault charges, civil rights violations, abuse of authority. The list went on. Several pointed out that if ordinary citizens had forced their way into someone's home, grabbed them, and ransacked their belongings, they'd be facing serious felony charges. The fact that these were federal agents made it worse, not better. Judge Forrester gave one statement through her attorney. It was brief and precise. She expressed disappointment that agents of the federal government had violated the constitutional protections they'd sworn to uphold. She called for a thorough investigation and meaningful accountability. She noted that if this could happen to a federal judge, what was happening to ordinary citizens who lacked her resources and platform? That last line hit like a hammer, because everyone paying attention knew the answer. This wasn't an isolated incident. It was simply the one that happened to someone with the power to fight back. The political fallout was immediate. Congressional committees announced hearings. Immigration advocacy groups filed complaints. The Judicial Conference issued a statement of concern. And quietly, behind closed doors, officials began discussing settlement numbers that made budget officers wince. But the most significant development came from an unexpected direction. Other judges started coming forward. Not publicly, but through official channels. Reporting incidents where immigration enforcement had overstepped. Cases where warrants seemed questionable. Situations where agents had been overly aggressive. Suddenly, the floodgates opened, revealing a pattern that had been invisible when viewed as isolated incidents, but became undeniable when examined collectively. A task force was assembled within 48 hours of the initial incident. Its mandate was simple: review every immigration enforcement action in the district for the past 3 years. Look for patterns. Identify problematic practices. Recommend systemic changes. The preliminary findings were staggering. Hundreds of questionable stops, dozens of warrantless entries, multiple cases of mistaken identity. And woven through everything, a disturbing pattern of targeting that suggested bias wasn't just present, but endemic. Kozlowski, Bannister, and Gutierrez found themselves at the center of a scandal far larger than one botched operation. Their case files were being examined, their previous arrests questioned. Complaints that had been dismissed were being reopened. Defense attorneys were filing motions in cases the three had worked, arguing that if they'd violated a federal judge's rights so flagrantly, what had they done to defendants who couldn't fight back? The answer to that question would eventually destroy dozens of prosecutions and lead to multiple case dismissals. But that revelation was still weeks away. For now, the three suspended agents sat in their homes, watching their careers disintegrate on cable news, finally understanding the magnitude of what they'd done. Judge Forrester returned to the bench exactly 1 week after the incident. She made no public statements beyond her initial response. She simply showed up, put on her robes, and began hearing cases. But everyone in that courtroom understood something had fundamentally changed. The quiet authority she'd always possessed now carried an edge. A reminder that justice wasn't abstract, that rights mattered, that no one, regardless of their badge or authority, was above the law they'd sworn to uphold. The settlement negotiations began 3 weeks later in a windowless conference room that felt deliberately designed to drain hope from everyone who entered. Judge Forrester's attorney, a woman named Diana Pacheco, who'd built her reputation dismantling government overreach, sat across from a team of 4 federal lawyers who looked like they'd aged a decade in 3 weeks. The government's opening offer was insulting. $200,000 and a formal apology. No admission of wrongdoing, no policy changes, just money and words designed to make the problem disappear quietly. Pacheco didn't even respond. She slid a folder across the table containing documentation of every constitutional violation, every procedural failure, every moment of that morning cataloged with legal precision that made the federal attorneys physically recoil. Then she stated Judge Forrester's terms. $7 million. Public admission of constitutional violations, immediate termination of all 3 agents involved, comprehensive reform of immigration enforcement protocols, mandatory retraining for every agent in the district, and an independent monitor to oversee compliance for 5 years. The lead federal attorney, a man who'd spent his entire career defending government agencies, actually laughed. He said the terms were absurd, that no court would ever award such damages, that they'd see her at trial. Pacheco smiled. She said that was perfectly fine because discovery would be fascinating. She'd subpoena every operation those 3 agents had ever conducted, every arrest, every warrant application, every incident report. She'd depose their supervisors, their trainers, everyone who'd signed off on their methods. And she'd do it all in public proceedings, where journalists could attend and cameras could record. The laugh died, because everyone in that room suddenly understood what a trial would mean. Not just embarrassment, but exposure of systemic problems that went far beyond one judge's violated rights. The task force findings would become public record. Defense attorneys would use the information to challenge hundreds of cases. The entire enforcement apparatus would be scrutinized in ways that could cripple operations for years. 2 hours later, the government's position had shifted dramatically. $5 million, admission of procedural failures, termination of 2 agents, suspension for the 3rd. Some policy reforms, details to be negotiated. It was progress, but not enough. Judge Forrester had made clear she wasn't interested in symbolic gestures. She wanted structural change that would protect the next person who wasn't a federal judge and couldn't fight back. The negotiations continued for 6 more sessions over 4 weeks. Each meeting brought incremental movement as the federal team realized they weren't negotiating with someone who needed the money or feared the fight. They were dealing with someone who understood power, precedent, and exactly how much damage this case could inflict if it proceeded. The final settlement, reached on a Friday afternoon when everyone was exhausted and desperate to end this, exceeded even Pacheco's initial demands in some areas. $6.2 million. Full public acknowledgement that constitutional violations had occurred. Immediate termination of all 3 agents with forfeiture of pensions. Complete overhaul of warrant procedures and enforcement protocols. Creation of a civilian oversight board with real authority. Mandatory bias training every 6 months. And perhaps most significantly, establishment of a victim compensation fund for anyone who could demonstrate they'd been subjected to similar violations. That last provision opened a floodgate. Within 3 months, over 200 claims had been filed. People who'd had their homes entered without warrants. Families separated based on mistaken identity. Citizens detained for hours because they looked foreign or spoke Spanish. Each claim was investigated. Many were substantiated. The compensation fund, initially allocated at $2 million, eventually paid out over $12 million as the scope of the problem became undeniable. Kozlowski, Bannister, and Gutierrez lost everything. Their careers ended in disgrace. Their pensions vanished. Their names became synonymous with constitutional violations in legal textbooks and training materials. Kozlowski filed for bankruptcy within 8 months. Bannister moved to another state and worked warehouse jobs under a different name. Gutierrez faced additional criminal investigation when it emerged he'd falsified details on warrant applications in previous cases, though prosecutors ultimately declined to file charges due to complexities around qualified immunity. But the real earthquake hit when the task force released its full report. 400 pages documenting systematic failures across the entire district. The findings were devastating. Immigration enforcement had operated for years with minimal oversight, inadequate training, and a culture that prioritized arrests over accuracy. Agents routinely made assumptions based on appearance. Warrants were rubber-stamped without proper review. Complaints were dismissed without investigation. Supervisors rewarded aggressive tactics without questioning methods. The statistics told a story that couldn't be denied. Latino citizens were 4 times more likely to be stopped than white citizens in similar circumstances. Warrant applications for immigration enforcement had approval rates exceeding 98%, compared to 73% for other law enforcement warrants. Mistaken identity cases had increased 40% over 3 years, and complaints about agent conduct had been filed at triple the rate of other federal agencies, yet disciplinary actions were rare. Congressional hearings began 2 weeks after the report's release. Judge Forrester was invited to testify. She declined, maintaining judicial propriety, but submitted a written statement that was read into the record. It described her experience in clinical detail, then posed a question that dominated news coverage for days. If this could happen to a sitting federal judge in her own home, with resources and knowledge to fight back, what was the true scope of violations against ordinary citizens who lacked those advantages? The question haunted everyone who heard it, because the answer was emerging through the compensation fund claims, through reopened cases, through stories that had been buried or ignored finally being told. A grandmother detained for 3 hours because she spoke limited English while waiting for a bus. A construction worker arrested at his job site based on an anonymous tip that proved false, losing his employment and unable to find new work because of the arrest record. A college student held overnight because her student visa had expired 2 days earlier, missing final exams that derailed her academic career. A family whose home was raided at dawn based on faulty address information, their children traumatized and their belongings destroyed. Each story represented a life disrupted, dignity violated, constitutional protections ignored. And each story had happened while supervisors looked away, while oversight failed, while a system designed to enforce immigration law had become something else entirely. Something that treated certain people as inherently suspicious based on nothing more than appearance or accent. The policy reforms that emerged from the settlement reshaped immigration enforcement across multiple districts, not just the one where Judge Forrester lived. Warrant applications now required detailed evidence, not vague tips. Home entries demanded supervisory approval and documentation of exigent circumstances. Mistaken identity protocols were established to prevent situations like Judge Forrester's. Body cameras became mandatory for all enforcement actions, and civilian oversight boards gained authority to review operations and mandate changes. Critics argued the reforms handcuffed legitimate enforcement efforts. Defenders pointed to the compensation fund claims as evidence the reforms were desperately needed. The debate raged in political circles and cable news, but on the ground, something fundamental had shifted. Agents now understood there were consequences for constitutional violations. Supervisors knew oversight bodies had teeth, and citizens, particularly those in immigrant communities, learned they had recourse when their rights were violated. Judge Forrester never spoke publicly about the settlement beyond a brief statement expressing hope that the reforms would prevent future violations. She returned fully to her judicial duties, her calendar packed with cases, her decisions as measured and precise as ever. But those who appeared in her courtroom noticed something. When prosecutors presented evidence from questionable stops or searches, her questioning became surgical. When defendants raised constitutional concerns, she listened with intensity that made attorneys on both sides nervous. When immigration status became relevant to a case, she demanded documentation and proper procedure with zero tolerance for shortcuts. She had become, without ever stating it explicitly, a living reminder that rights mattered and that violations carried costs far beyond immediate inconvenience. The transformation in her courtroom became a quiet revolution that lawyers learned to navigate carefully. defense attorneys started citing her rulings in other jurisdictions, creating precedent that spread like ripples across legal waters. Prosecutors complained privately that she had become biased, that one bad experience had warped her judgment. But those complaints never gained traction because her decisions were legally sound, meticulously reasoned, impossible to successfully appeal. What they didn't understand was that Judge Forrester hadn't changed her legal philosophy. She had simply stopped assuming good faith where evidence suggested otherwise. She had stopped giving law enforcement the benefit of doubt when that benefit had been weaponized against citizens. She had learned firsthand that constitutional protections meant nothing if courts didn't enforce them vigorously. 3 years after the settlement, a case appeared on her docket that brought everything full circle. Immigration enforcement had detained a man outside a grocery store, claiming he matched a deportation warrant. The detention lasted 6 hours before they realized the warrant was for someone with a similar name but different birth date and physical description. The man sued for violation of his Fourth Amendment rights. The government moved to dismiss, arguing qualified immunity protected the agents from liability. Judge Forrester denied the motion in a 23-page opinion that became required reading in law schools. She systematically dismantled the qualified immunity defense, pointing out that clearly established law prohibited detentions based on name similarity alone. She noted that the agents had access to photographs, fingerprints, and detailed physical descriptions, but chose not to verify identity before depriving someone of liberty for 6 hours. She described the detention as not merely negligent, but deliberately indifferent to constitutional requirements. The opinion went further. She analyzed patterns in the agency's detention practices, noting statistical disparities that suggested targeting based on appearance rather than evidence. She cited the compensation fund data from her own settlement, showing this wasn't an isolated incident, but part of systemic problems. She concluded that qualified immunity couldn't shield agents who ignored obvious constitutional requirements in pursuit of enforcement efficiency. The government appealed immediately, but the appellate court affirmed her ruling in language that echoed her reasoning. The Supreme Court declined to review the case, letting the opinion stand. Within months, it was being cited nationwide, making it substantially harder for agents to hide behind qualified immunity after questionable detentions. But legal victories on paper didn't erase the human costs already inflicted. The compensation fund kept processing claims years after the settlement, each one documenting damage that money couldn't fully repair. A woman who lost her job after a 3-day detention based on mistaken identity and couldn't find equivalent employment afterward. A man whose children were placed in emergency foster care when he was detained, creating trauma that required years of therapy. A family whose immigration applications were denied because an unlawful detention created a false arrest record that authorities refused to expunge despite court orders. The fund administrators documented everything, creating a record that advocacy groups used to push for national policy changes. Congressional hearings featured testimony from claimants, their stories broadcast into homes across the country. Legislators who had previously defended aggressive enforcement tactics found themselves confronted with constituents who had been swept up in operations that violated basic rights. Proposed legislation emerged requiring warrant specificity, limiting pretextual stops, mandating verification procedures before detention, creating independent review of enforcement operations. The bills faced fierce opposition from those who claimed they would cripple border security and immigration enforcement. But the opposition couldn't explain away the compensation fund data, couldn't dismiss the federal judge who had experienced violation firsthand, couldn't ignore the mounting evidence of systemic abuse. Judge Forrester never testified at those hearings, maintaining her judicial role by staying out of legislative debates. But her settlement, and the reforms it generated, became the framework for proposed changes. Advocates cited her case as proof that no one was immune from enforcement overreach, that constitutional protections had eroded to dangerous levels, that systemic reform wasn't just necessary, but urgent. The agency that had raided her home underwent leadership changes, though officials insisted those changes were unrelated to the settlement. The new director implemented training programs emphasizing constitutional limits and individual rights. He created an internal review office with authority to investigate complaints and recommend disciplinary action. He established protocols requiring supervisory approval before home entries and verification procedures before detentions. Critics noted these were essentially the reforms mandated by Judge Forrester's settlement, just repackaged as internal initiatives. The director never acknowledged that connection publicly, but agents understood the message. The old approach had generated massive liability, destroyed careers, and created political backlash. The new approach prioritized doing enforcement work correctly over doing it quickly. Yet resistance persisted at ground level, where some agents viewed the reforms as obstacles rather than safeguards. Anonymous surveys revealed significant percentages believed constitutional restrictions made their jobs impossible, that oversight mechanisms were designed to punish rather than improve performance, that the settlement had empowered people who deserved scrutiny to avoid accountability. Those attitudes ensured that violations continued, though at reduced frequency and with greater consequences when discovered. The oversight boards established by the settlement investigated complaints aggressively, sustaining discipline that previous systems had dismissed. Agents learned that body camera footage would be reviewed, that supervisors would be questioned, that claims of good faith wouldn't automatically shield them from accountability. The cultural shift took years to solidify, resisted by those who preferred the old approach, where enforcement priorities trumped individual rights. But gradually, through disciplinary actions and training and leadership changes and legal defeats in cases like the one Judge Forrester decided, a new normal emerged. Not perfect, not without ongoing problems, but fundamentally different from what had existed before a federal judge experienced firsthand what countless others had endured without resources to fight back. Judge Forrester's career continued with distinction, her rulings respected even by those who disagreed with specific decisions. She never sought publicity about the settlement, declining interview requests and speaking invitations that would have given her a national platform. She preferred to let her judicial work speak for itself, writing opinions that shaped law and protected rights without fanfare or self-promotion. But in immigrant communities, in civil rights organizations, in law school classrooms, her name carried weight beyond her judicial decisions. She represented something powerful, the idea that justice could prevail even against institutional indifference, that constitutional rights meant something, even when enforcing them was inconvenient, that one person with resources and determination could force systemic change that protected thousands of others. The settlement she negotiated created frameworks that spread to other jurisdictions, other agencies, other contexts where government power threatened individual liberty. Oversight boards using her model appeared in cities across the country. Training programs incorporated lessons from her case. Lawyers arguing against qualified immunity cited her opinions. Legislators crafting reform proposals used her settlement as a template. 5 years after agents burst through her door at dawn, Judge Forrester sat in her chambers reviewing case files as always. Her routine restored, her life returned to the careful order she preferred. But outside those chambers, the impact of what she had endured and how she had responded continued spreading, protecting people who would never know her name, but benefited from the systems she had forced into existence. That legacy mattered more than any single ruling she would write, more than any case she would decide. It proved that accountability was possible, that constitutional protections had meaning, that violations carried costs beyond immediate inconvenience. Sometimes, justice required someone with power to experience powerlessness, with authority to face its abuse, with resources to fight back in ways others couldn't. Judge Forrester had become that person not by choice, but by circumstance, and she had used that position to force changes that rippled far beyond her own experience, protecting rights that belonged to everyone, regardless of status or background or ability to defend themselves. The evening news still runs stories about immigration enforcement. Political debates still rage about borders and security and who belongs where. But in one federal courthouse, in courtrooms across the district, in oversight board meetings and training sessions and policy discussions, something fundamental has shifted. Because 3 agents made a catastrophic choice on a quiet residential street. Judge Diane Forrester never wanted to become a symbol. She wanted to eat dinner with her sister, laugh about her grandson, enjoy an ordinary evening in the home she'd worked her entire career to afford. Instead, she became the case study that proved what advocacy groups had been saying for years: that enforcement without accountability becomes tyranny. That badges don't grant permission to violate rights. That power unchecked will always find vulnerable targets until someone forces consequences. The compensation fund that emerged from her settlement has paid out millions to people whose stories would otherwise have disappeared into bureaucratic files and dismissed complaints. Each claim represents a life disrupted, dignity violated, constitutional protections ignored, while systems designed to prevent such violations looked the other way or actively enabled them. Those systems have changed, not completely, not perfectly, but meaningfully. Warrant applications now face scrutiny that would have prevented the raid on Judge Forrester's home. Oversight boards have authority that makes agents think twice before cutting corners. Training programs emphasize rights protection because the alternative costs careers and generates massive liability. Body cameras document encounters that previously existed only in disputed accounts, weighted toward those with badges. These changes didn't happen because officials suddenly discovered constitutional principles. They happened because one violation targeted someone with resources to fight back, knowledge to challenge procedures, platform to force accountability. They happened because a federal judge experienced what countless others had endured and refused to let it pass quietly into settlement agreements that buried truth beneath confidentiality clauses. The three agents who destroyed their careers that evening probably still don't fully understand what they did wrong. They followed procedures they'd used countless times before. They acted on intelligence they'd been trained to trust. They applied force they believed their authority permitted. The only difference was their target had power to respond. And that difference ended everything they built. Their careers became cautionary tales used in training sessions worldwide. Their names appear in legal textbooks as examples of what not to do. Their actions generated reforms that reshaped immigration enforcement beyond anything they could have imagined while standing on that porch demanding entry without legal justification. Judge Forrester sits in her chambers today reviewing case files, writing opinions, conducting the careful work of justice that fills her calendar. She doesn't talk about what happened beyond that initial statement years ago. She doesn't need to. Her judicial decisions speak clearly about what she learned, what she values, what she will no longer tolerate from those who wield government power against vulnerable populations. The question she posed during congressional testimony haunts everyone who heard it. If this could happen to a federal judge with resources and knowledge and institutional power, what happens to ordinary citizens who lack those advantages? The Compensation Fund answered that question in painful detail, documenting violations that would have remained invisible if one person hadn't experienced them firsthand, and refused to accept that such treatment was normal or acceptable or just the cost of living in communities targeted by aggressive enforcement. 3 agents lost their careers. 1 judge gained a platform. Thousands of people gained protections they didn't have before. The balance sheet doesn't make the violation right or erase the damage done, but it proves that accountability is possible when systems are forced to function as designed, when oversight has real authority, when consequences extend beyond the immediate victims to those who committed violations. The dinner table on Sydenham Avenue has hosted many meals since that evening, when pounding interrupted laughter and conversation. The front door was repaired after agents broke through the chain lock. Life returned to normal routines and quiet evenings. But the impact of what happened there continues spreading through legal systems and policy frameworks and training programs that exist because one federal judge refused to let constitutional violations disappear into settlement silence. That refusal matters more than any individual ruling she will write. It transformed personal violation into systemic reform. It proved that rights mean something when institutions enforce them vigorously. It demonstrated that power without accountability will always find targets until someone forces consequences that make violations too expensive to continue. Justice doesn't always prevail. Systems often protect their own at the expense of those they're meant to serve. But sometimes, when circumstances align and someone with resources fights back and evidence is overwhelming, change becomes possible. Judge Forrester's case represents that rare alignment, that moment when accountability pierced institutional indifference and forced reforms that protected thousands who would never know her name, but lived safer because she refused to accept that violations were simply how things worked. Now, watching footage like this, it can really stick with you, right? Some of these clips stay in your head, especially late at night when you're trying to fall asleep. And speaking of sleep, a lot of you have told me you're waking up at 2 or 3 a.m. and just lying there. Can't shut your mind off. And the next day you're dragging through everything. I came across a simple 21-day sleep guide that's helped thousands of people fix exactly that. No pills, no apps, no gadgets. Just a step-by-step plan that actually works. It's only $15. I put the link in the description if you want to check it out. All right, I'll catch you in the next one.
Ma'am, I said ID now. Stop playing games.
I've committed no violation. You have no lawful basis for this stop.
You're in an area known for illegal crossings, and you expect me to just assume you belong here?
I am a federal judge.
You are making a catastrophic mistake.
Judge Vanessa Sterling had been a federal judge for 12 years. She'd presided over hundreds of cases, interpreted constitutional law, and sworn an oath to uphold justice. But none of that mattered to the 2 ICE agents standing outside her car at a Shell gas station on a Tuesday morning. They saw a black woman in professional attire and made an assumption that would cost them everything. She was filling up her Mercedes before heading to the courthouse. The gas pump clicked. She replaced the nozzle. That's when the unmarked SUV pulled up behind her, blocking her exit. 2 men stepped out wearing tactical vests with ICE printed across the chest. Agent Kyle Brennan and Agent Travis Mendoza had been with Immigration and Customs Enforcement for 8 and 6 years, respectively. They were about to make the biggest mistake of their careers. Judge Sterling asked again what violation justified the stop. Brennan repeated his demand for identification. His hand rested on his belt near his weapon. Mendoza circled around to the passenger side of her vehicle, peering through the windows. Other customers at the gas station started watching. Someone pulled out their phone. "I'm a federal judge. This stop is unconstitutional. You have no authority to detain me without reasonable suspicion of a crime." Brennan smirked. "Sure you are. And I'm the president. License and registration. Last time I'm asking nicely." What happened next would be dissected frame by frame in federal court. Judge Sterling, maintaining her composure despite the rage building inside her, slowly reached into her purse. She pulled out her judicial identification, the kind issued only to sitting federal judges, complete with her photo and the seal of the federal judiciary. She held it up clearly. Brennan glanced at it for maybe 2 seconds. He handed it back. "That doesn't mean anything. We still need to verify your immigration status." Judge Sterling's jaw tightened. "You just looked at federal judicial credentials and dismissed them. This is unlawful detention. I'm ordering you to step aside and let me leave." "You're not ordering us to do anything." Mendoza's voice came from behind her. "We have authority under federal immigration law to conduct stops and verify status. Not without individualized, reasonable suspicion you don't. And you certainly don't have authority over a sitting federal judge. This encounter is over." She moved toward her driver's door. Brennan stepped forward, blocking her path. His hand moved to his handcuffs. That's when Judge Sterling made the decision that would ultimately save her, but destroy them. She pulled out her cell phone and began recording. "I am Federal Judge Vanessa Sterling of the Northern District. I am being illegally detained by 2 ICE agents at the Shell station on Riverside Boulevard. I have presented my credentials. I have committed no violation. I am documenting this unconstitutional stop." "Turn off that phone." Brennan's voice rose. "You're interfering with a federal investigation." I am the investigation, and this recording is evidence of your constitutional violations. Mendoza moved closer. His face appeared on camera. Ma'am, if you don't comply right now, we will arrest you for obstruction. The absurdity of the threat hung in the air. 2 immigration agents threatening to arrest a federal judge for refusing an unlawful detention. But Brennan and Mendoza weren't thinking about consequences. They were thinking about control, about authority being challenged, about a black woman who wouldn't submit. Brennan grabbed Judge Sterling's wrist. The phone nearly dropped, but she held on. Mendoza moved in from the other side. Within seconds, they had forced her against her own vehicle. The phone was still recording, now capturing shaky footage of the gas station pavement and the agent's boots. You are making a catastrophic mistake. Judge Sterling's voice remained steady even as metal handcuffs closed around her wrists. I am a federal judge. You are committing multiple federal crimes right now. Save it for processing. Brennan guided her toward their SUV. Other gas station customers stood frozen, watching a woman in a tailored suit being arrested at a fuel pump. 3 people were recording now. One man shouted asking if she needed help. Mendoza told him to back away or face obstruction charges himself. The drive to the ICE field office took 19 minutes. Judge Sterling sat in the back seat, hands cuffed behind her, saying nothing. She had said everything that mattered already. Now she would let the system respond. And respond it would, with a force that Brennan and Mendoza couldn't begin to imagine. At the field office, they walked her inside like she was a dangerous criminal. Other agents glanced over with mild curiosity. Just another person being processed. Mendoza logged her into the system. Name, physical description, location of apprehension. He typed quickly, barely looking at the screen. Then came the part where they collect personal belongings. Judge Sterling's purse was emptied onto a metal table. Wallet, keys, lipstick, tissues, phone, and then the items that should have stopped everything immediately. Her judicial credentials, the ones Brennan had dismissed at the gas station. Her federal courthouse access badge with embedded security chip. Her Bar Association membership showing she'd been a licensed attorney for 23 years before her appointment to the bench. A business card identifying her as Judge Vanessa Sterling, U.S. District Court. The processing agent, a woman named Officer Rebecca Patel, picked up the credentials. She studied them carefully. She looked at Judge Sterling, then at Brennan and Mendoza, who were standing nearby filling out paperwork. Did you see these? Brennan barely looked up. Yeah, they're fake. She claimed to be a federal judge, obviously lying. Patel had processed thousands of people. She knew what fake credentials looked like. These weren't fake. The holographic seals, the embedded security features, the weight of the cards, everything was authentic. She opened her computer and pulled up the Federal Judiciary Directory. What's your full name and district? Judge Vanessa Sterling, Northern District. Patel typed. The search results loaded. There was the photo matching the woman sitting in front of her. The biography listing her education, her appointment by the president 8 years ago, her confirmation by the Senate, recent cases she'd presided over. Everything matched. Patel's face went pale. She stood up slowly and walked directly to her supervisor's office. She didn't knock, just opened the door. Her supervisor, District Director Nathan Cross, looked up annoyed at the interruption. We have a significant problem. 5 minutes later, Cross was standing in the processing area, staring at Judge Sterling. He'd pulled up the same federal directory on his own computer. He'd called the courthouse and confirmed she was scheduled to be in court that afternoon. He'd looked at Brennan and Mendoza's arrest report, which listed 0 specific violations, 0 reasonable suspicion, just vague references to an immigration verification stop. Cross had been with ICE for 15 years. He'd navigated political controversies, policy changes, and public scrutiny. But he'd never dealt with anything like this. His agents had just arrested a sitting federal judge without a warrant, without cause, without any legal justification whatsoever. Release her immediately. His voice was quiet but sharp. Remove the handcuffs, return all her belongings, and someone get me the agency's legal counsel on the phone right now. Judge Sterling stood as the handcuffs came off. She rubbed her wrist where the metal had pressed into her skin. She collected her belongings methodically, checking that everything was present. Her phone, still containing the recording. Her credentials, now validated. Her dignity, somehow intact despite everything. Cross approached carefully. "Your Honor, I apologize for this incident. There's been a serious misunderstanding." "Director Cross, there was no misunderstanding. Your agents conducted an unlawful stop, ignored federal credentials, and arrested a sitting federal judge. Those are facts, not misunderstandings. We'll be conducting a full internal investigation. You'll be facing a federal civil rights lawsuit and likely criminal charges for violating my constitutional rights under color of law." She walked toward the exit. Brennan and Mendoza stood against the wall, finally understanding that something had gone terribly wrong. Judge Sterling paused and looked directly at them. "You'll be hearing from me again. In court." The door closed behind Judge Sterling with a soft click that somehow felt louder than any slam could have been. She stood outside the ICE facility in the harsh afternoon sunlight, free, but fundamentally changed by what had just happened. Her phone buzzed immediately. 17 missed calls, 42 text messages. Her clerk, her staff, the courthouse security, all wondering where she was. She had missed an entire afternoon of scheduled hearings, cases that mattered, people whose lives depended on her rulings, left waiting while she sat handcuffed in a processing room for the crime of existing in her own skin. She didn't call anyone back yet. Instead, she opened the voice recording app on her phone. The file was still there. 23 minutes and 14 seconds of audio capturing every word spoken during that traffic stop. Every illegal question. Every ignored credential. Every moment of her constitutional rights being violated by federal agents who should have known better. Judge Sterling walked to her car, still parked exactly where Brennan had forced her to leave it. A parking ticket fluttered under the windshield wiper. Even that felt like a final insult. She pulled it out and actually laughed, a sharp, bitter sound that surprised her. Arrested without cause and ticketed for the privilege. The drive back to the courthouse took 30 minutes through heavy traffic. She used the time to think, to plan, to shift from victim back to judge. Because that's what she was, regardless of what agents Brennan and Mendoza saw when they looked at her. A federal judge with the full power of the judiciary behind her. When she arrived, the courthouse was in controlled chaos. Her clerk practically ran to meet her at the entrance. "Judge Sterling, we've been trying to reach you for hours. Are you all right? What happened?" "Reschedule everything from this afternoon, clear my calendar for tomorrow morning, and get me the contact information for the Department of Justice Office of Professional Responsibility and the Inspector General for Homeland Security." Her chambers felt different when she entered. The same mahogany desk, the same leather chair, the same law books lining the walls. But she wasn't the same person who had left that morning. Something had shifted. The theoretical cases she presided over, the abstract questions of constitutional law and civil rights, they weren't abstract anymore. They were personal. They were real. They were burned into her wrists where the handcuffs had been. She spent the next 4 hours making calls. The first was to her husband, a college professor who listened in stunned silence as she explained what happened. The second was to her attorney, because even judges need lawyers when their rights are violated. The third was to the chief judge of her district, because this wasn't just a personal matter. This was an assault on the judiciary itself. By 7 that evening, the machinery of justice had begun its grinding work. The Department of Justice opened a preliminary inquiry. The Inspector General's office assigned investigators. The chief judge issued a statement expressing grave concern and demanding a full accounting. And Judge Sterling's attorney filed a notice of intent to sue, the first step toward a federal civil rights lawsuit that would cost the government far more than money. But that was just the official response. The unofficial response was spreading through the legal community like wildfire. Judges talked to other judges. Attorneys shared the story with colleagues. Law clerks posted about it on private forums. By the next morning, every legal professional in the district knew that 2 ICE agents had arrested a sitting federal judge, and the implications were staggering. Meanwhile, back at the ICE facility, Director Cross was having the worst night of his career. He sat in his office reviewing the arrest report for the 100th time, searching for anything that might justify what his agents had done. There was nothing. No warrant, no probable cause, no reasonable suspicion. Just two agents who saw a black woman and decided that was sufficient reason to demand papers and make an arrest when she objected. The agency's legal counsel had been brutally clear. This case was indefensible. The agents had violated clearly established constitutional rights. Qualified immunity wouldn't protect them. The agency would likely lose any lawsuit. The only question was how much it would cost. Cross called Brennan and Mendoza into his office at 6 the next morning. Both agents arrived looking exhausted. Word had spread through the facility about exactly who they had arrested, and neither had slept well. You're both suspended without pay, effective immediately. You'll surrender your badges and firearms. You're prohibited from discussing this case with anyone except your attorneys and our investigators. Do you understand? Brennan's jaw tightened. This is political correctness gone crazy. We were doing our jobs. Your job doesn't include arresting federal judges without cause. Your job doesn't include ignoring valid credentials. Your job doesn't include violating constitutional rights. She showed us a fake ID. Anyone can print a card. Cross slid a printed page across the desk. It was Judge Sterling's official biography from the Federal Judiciary website, complete with her photo, her credentials, her 8 years on the bench. Anyone can print a card, but not anyone can have their photo and biography on the official federal court website. Not anyone can be listed in the National Judiciary Database. You didn't check because you didn't want to believe her. Mendoza spoke for the first time. What happens now? Now you get attorneys. Good ones. Because the Department of Justice is investigating you for civil rights violations under color of law. That's a federal felony. And Judge Sterling will be filing a civil lawsuit. You're both looking at criminal charges and personal financial liability. The color drained from Mendoza's face. We could go to prison? Cross nodded. People have gone to prison for less egregious violations than arresting a federal judge without cause. The investigation moved quickly because the evidence was overwhelming. The dashboard camera from the ICE vehicle showed the entire stop. Judge Sterling's phone recording captured every conversation. The processing paperwork documented the arrest. There were no gaps, no ambiguities, no questions about what happened. Within 2 weeks, the Department of Justice made its decision. Criminal charges would be filed against both agents: deprivation of rights under color of law, false arrest, and abuse of authority. Each charge carried potential prison time. The civil lawsuit followed shortly after. Judge Sterling's attorney filed a comprehensive complaint in federal court. It named Brennan and Mendoza individually, named ICE as an agency, and named the Department of Homeland Security. The damages sought were substantial, but the complaint made clear this wasn't primarily about money. It was about accountability. The case was randomly assigned to another federal judge in the same district. Judge Thomas Crawford had served on the bench for 12 years and knew Judge Sterling professionally. He read the complaint with increasing disbelief, then reviewed the evidence attached as exhibits. The recordings, the video, the documented timeline. Everything confirmed exactly what the complaint alleged. This will not be a long trial, he thought. This will be a settlement negotiation. He was right. The government's attorneys reviewed the same evidence and reached the same conclusion. They had no defense. Their own agents' actions were documented beyond any possibility of dispute. Going to trial would mean playing that dashboard camera footage for a jury, letting them hear 2 federal agents dismiss a judge's credentials as fake, watching them arrest her without legal justification. Settlement discussions began within a month. The government offered $500,000. Judge Sterling's attorney countered with $2.5 million. Not because Judge Sterling needed the money, but because the number had to be large enough to hurt, to force systemic change, to make sure this never happened to anyone else. The negotiations continued for weeks. Meanwhile, the criminal case moved forward on a parallel track. Brennan and Mendoza both retained private attorneys using their life savings. Both were advised to consider plea agreements because taking these charges to trial was effectively suicide. Brennan refused. He maintained he'd done nothing wrong, that he was being persecuted for enforcing immigration law. His attorney told him he was making a catastrophic mistake. Brennan fired his attorney and hired another one, who told him the same thing. Mendoza was more realistic. She understood that the evidence was damning, that her career was over, that her only hope of avoiding significant prison time was cooperation. Her attorney negotiated a plea deal. Mendoza would plead guilty to 1 count of deprivation of rights under color of law. She would testify against Brennan if his case went to trial. In exchange, prosecutors would recommend probation instead of prison. She took the deal. Standing in federal court, ironically just 2 floors below where Judge Sterling's chambers were located, Mendoza pleaded guilty. She admitted that she had participated in an unlawful stop and arrest. She acknowledged violating Judge Sterling's constitutional rights. She accepted responsibility for her actions. Judge Crawford, presiding over the plea hearing, asked if she understood what she was admitting. Mendoza said yes. He asked if anyone had forced or coerced her plea. She said no. He accepted the guilty plea and scheduled sentencing for 3 months later. Brennan watched all of this happen and still refused to accept reality. His new attorney begged him to reconsider. The evidence was overwhelming. His former partner had turned against him. He was going to lose at trial and face years in federal prison. "Please," his attorney said, "take a deal while there's still time." Brennan refused. He would take his chances with a jury. He believed 12 ordinary citizens would understand he was just doing his job, just following procedures, just trying to enforce the law. His attorney knew better, but couldn't force him to see reason. The civil settlement was finally reached 4 months after the arrest. The government agreed to pay Judge Sterling $1.8 million. More importantly, they agreed to policy changes. All federal agencies would implement mandatory training on implicit bias and proper identification verification. Dashboard cameras would be reviewed quarterly for constitutional violations. Agents who made unlawful stops would face immediate suspension pending investigation. The settlement terms were made public, and the dollar amount made headlines. But Judge Sterling cared more about the policy changes. She wanted to prevent this from happening again, to the next person, to someone who didn't have her resources or legal knowledge. The criminal trial against Brennan began 6 months after the arrest. The courtroom was packed. Local media filled the gallery. Civil rights organizations sent observers. Federal employees came to watch one of their own face justice. The prosecution's case was devastating from the opening statement. They walked the jury through every moment of that traffic stop. They explained how Judge Sterling had done nothing wrong, had presented valid credentials, had asked reasonable questions. They showed how Brennan ignored all evidence contradicting his assumptions, how he invented justifications after the fact, how he arrested a federal judge for the crime of questioning his authority. The dashboard camera footage played on large monitors. Every juror watched as Brennan dismissed Judge Sterling's credentials without even examining them properly. They heard him tell her to stop talking, to stop asking questions, to comply or face arrest. They saw him handcuff a woman who had committed no violation whatsoever. The prosecution called Mendoza as a witness. She testified for 3 hours. She explained that she had tried to tell Brennan they should verify the credentials. She admitted she should have tried harder, should have insisted, should have refused to participate. She acknowledged her own guilt, but made clear that Brennan had been the driving force behind everything that happened. Cross-examination was brutal. Brennan's attorney tried to paint Mendoza as a liar trying to save herself. He suggested she was the one who wanted to make the arrest and was now blaming Brennan. But the dashboard footage contradicted everything he claimed. The video showed exactly who made each decision, who gave each command, who chose escalation over verification. Expert witnesses testified about proper law enforcement procedures. A former ICE supervisor explained that Brennan had violated every protocol designed to prevent exactly this kind of mistake. A constitutional law professor walked the jury through the Fourth Amendment, explaining how Brennan's actions constituted a clear violation of Judge Sterling's rights. Judge Sterling herself took the stand. She described the humiliation of being arrested in her own vehicle. She explained how she had remained calm despite knowing she was being unlawfully detained. She recounted the fear she felt, not physical fear, but fear that anything she did or said would be used to justify violence against her. The defense tried to suggest Judge Sterling had been uncooperative, that she had escalated the situation by asking questions. Her attorney objected immediately. Asking questions is not a crime. Asserting your rights is not obstruction. The judge sustained the objection and instructed the jury to disregard the implication. Brennan took the stand in his own defense. His attorney had advised against it, but Brennan insisted. He needed to explain himself, to make the jury understand. His testimony was a disaster. He claimed he had reasonable suspicion based on Judge Sterling's presence in a high-traffic area for undocumented individuals. The prosecution immediately challenged this. What high-traffic area? A residential street in a middle-class neighborhood? Brennan couldn't provide specifics. He said Judge Sterling seemed nervous. The dashboard footage showed her perfectly calm. He claimed her credentials looked suspicious. He couldn't articulate what specifically seemed suspicious about valid federal documents. The prosecution destroyed him on cross-examination. They played the video again, pausing at key moments. When exactly did you verify these credentials before dismissing them? Brennan admitted he hadn't run them through any system. Did you call the courthouse to confirm Judge Sterling's identity? No. Did you consult a supervisor before making the arrest? No. Did Judge Sterling commit any traffic violation that justified the initial stop? A long pause. No. So you stopped her based on what exactly? Another pause. Her appearance in that area at that time. Her appearance, yes. And what about her appearance made you suspicious? Brennan realized the trap too late. There was no answer he could give that wouldn't sound like exactly what it was. The jury deliberated for 4 hours. They returned guilty verdicts on both counts: deprivation of rights under color of law and making false statements in official reports. Brennan sat motionless as the verdicts were read. His attorney placed a hand on his shoulder, but Brennan didn't react. Sentencing was scheduled for 2 months later. Brennan remained free on bond until then, but his life as he knew it was over. The federal conviction meant he could never work in law enforcement again. His pension was forfeit. His reputation was destroyed. Mendoza's sentencing came first. She stood before Judge Crawford, the same judge who had accepted her guilty plea. Her attorney presented letters from family and colleagues describing her years of service, her previously clean record, her genuine remorse. Mendoza herself addressed the court. She apologized to Judge Sterling, who sat in the gallery. She acknowledged that following orders was not an excuse, that she had her own moral responsibility to refuse unlawful commands. She said she would spend the rest of her life trying to make amends. Judge Crawford sentenced her to 3 years of probation, 500 hours of community service, and a $10,000 fine. He noted that her cooperation and genuine remorse weighed heavily in his decision, but emphasized that what she did was serious, that she had betrayed her oath and violated someone's fundamental rights. Mendoza accepted the sentence without appeal. Brennan's sentencing 2 weeks later was entirely different. He showed no remorse. His attorney presented a sentencing memorandum arguing that Brennan had acted in good faith, that mistakes happen in law enforcement, that prison time would be excessive. The prosecution's memorandum told a different story. It detailed Brennan's history of complaints, the pattern of stops targeting people of color, the multiple warnings from supervisors that he had ignored. This was not one mistake. This was a pattern of constitutional violations that finally caught up with him. Judge Sterling submitted a victim impact statement. She described the lasting effects of being treated like a criminal in her own community. She explained how she still felt anxiety during any interaction with law enforcement, how the arrest had undermined her sense of safety and belonging. She noted that as a judge, she understood the legal system better than most victims, yet still felt powerless in that moment. What about people without her knowledge, resources, or position? How many others had Brennan violated who never got justice? Judge Crawford read the entire statement aloud in court. Then he addressed Brennan directly. You were given authority and power to serve your community. You abused that power. You targeted someone based on assumptions and bias, then arrested her when she dared to question you. Even now, after a jury convicted you, you show no understanding of what you did wrong. That concerns me deeply. The sentence was harsh. 30 months in federal prison, 3 years of supervised release following incarceration, a $50,000 fine, restitution to Judge Sterling for attorney fees and costs. Brennan's attorney immediately filed notice of appeal, but everyone in that courtroom knew it was futile. The evidence was overwhelming, the verdict sound, the sentence within guidelines. The appeal would fail. Brennan was taken into custody immediately. No more freedom while waiting, no more chances to flee or influence anyone. Federal marshals placed him in handcuffs and led him out of the courtroom. The same handcuffs he had placed on Judge Sterling now bound his own wrists. The symmetry was not lost on anyone present. Judge Sterling watched him leave. She felt no satisfaction, no sense of victory, just exhaustion and sadness that it had come to this, that someone entrusted with authority had abused it so thoroughly. Outside the courthouse, reporters surrounded her. She made a brief statement. Justice has been served, but justice delayed is justice diminished. This should never have happened. The system failed long before that traffic stop. Multiple complaints were ignored, warning signs dismissed, patterns overlooked. Real accountability means preventing these violations, not just punishing them after the damage is done. The reporters dispersed within minutes, but the real fallout was just beginning. Within 24 hours, a civil rights organization filed a class action lawsuit against the entire police department. They had compiled records going back 7 years, showing systematic patterns of racial profiling, unlawful stops, and retaliatory arrests. Judge Sterling's case wasn't unique. It was just the one that finally made headlines because of who she was. The lawsuit identified 43 other victims. A teacher arrested for jaywalking after questioning why an officer stopped him. A nurse detained for suspicious behavior while sitting in her own car outside her apartment. A college student handcuffed for matching the description of a suspect who was 6 inches shorter and 30 pounds heavier. A grandfather tackled during a wellness check his own daughter had requested. Every single victim was Black or Latino. Every single officer involved had complaint histories that were ignored. The patterns were undeniable once someone actually looked. But here's what made it worse. Internal Affairs had the data all along. They knew which officers generated the most complaints. They knew which precincts had the highest rates of use of force against minorities. They knew supervisors were signing off on questionable arrests without proper review. They simply chose not to act because acting would mean admitting there was a problem. And admitting problems meant liability, bad press, budget fights, political headaches. So they buried it. Filed reports in databases no one searched. Marked complaints as unfounded without real investigation. Transferred problem officers to different districts instead of firing them. The system protected itself while the community suffered. The discovery process in the class action revealed emails that should never have been written. Supervisors joking about arrest quotas in certain neighborhoods. Officers sharing memes mocking people they had detained. A lieutenant telling subordinates to find reasons to stop people in high-crime areas, which was code everyone understood. The department's own training materials included outdated techniques that civil rights experts said practically encouraged constitutional violations. None of this was accidental. It was institutional rot that had been festering for decades. Judge Sterling became the face of the lawsuit, though she never wanted that role. She gave depositions, appeared at hearings, testified before city council. Every appearance meant reliving that traffic stop, answering questions about how it felt, explaining the fear and humiliation over and over. She did it anyway, because the 43 other victims deserved someone with her platform fighting alongside them. Most of them didn't have legal backgrounds. Most couldn't afford the kind of attorneys this case required. Most would have been ignored if they had tried fighting alone. The city's defense strategy was predictable. They claimed these were isolated incidents by officers who didn't represent department values. They pointed to diversity training programs and community outreach initiatives as proof they took these issues seriously. They argued that policing is difficult, that split-second decisions sometimes go wrong, that hindsight is 20/20. Their attorneys painted the officers as dedicated public servants who made honest mistakes under pressure. The problem was the evidence. Thousands of pages of data showing the mistakes somehow always happened to the same communities. Video footage from body cameras and dash cams showing officers lying in their reports. Testimony from sergeants admitting they approved arrests without reviewing the facts because they trusted their officers' judgment. That trust was misplaced, and now the city was paying for it. 18 months after the lawsuit was filed, the city settled. $230 million, split among the 43 victims and their attorneys. Comprehensive reforms, including independent oversight, mandatory body cameras that couldn't be turned off, automatic review of any arrest where charges were dropped, and termination for officers who filed false reports. The police union fought every single reform, claiming they would make officers hesitant to act, that crime would skyrocket, that good cops would leave the force. Some did leave. Most stayed. Crime didn't increase. Complaints dropped by 60% within the first year. Judge Sterling received $4.7 million from the settlement. She donated $3 million to organizations supporting criminal justice reform. She used another $1 million to establish a legal defense fund for people who couldn't afford attorneys when challenging unlawful arrests. She kept the rest, not because she needed it, but because accepting it meant the city officially acknowledged what they had done to her. The money was accountability in its most tangible form. Brennan served 22 months before being released to a halfway house. Federal prisoners typically serve 85% of their sentence if they behave, and Brennan kept his head down. He worked in the prison library, took classes, stayed out of trouble. He never admitted guilt, never expressed genuine remorse, but he learned to say the right things during parole hearings. When he was finally released, he moved to a different state where no one knew his name or his history. He couldn't work in law enforcement anymore. His conviction made that impossible. He took a job doing private security at a warehouse, checking badges and watching cameras. The irony of a man who abused authority, now working minimum wage security, wasn't lost on anyone who knew his story. Mendoza had a different trajectory. Her cooperation and genuine remorse opened doors Brennan's defiance had closed. After completing probation, she became an advocate. She spoke at police academies about what she had done wrong and why. She testified before legislative committees considering reforms. She met with community groups who had every reason to hate her and answered their questions honestly, no matter how uncomfortable. Some people forgave her. Many didn't. She accepted both responses as consequences she had earned. Judge Sterling returned to the bench 6 months after the settlement. Some questioned whether she could be impartial in cases involving police testimony. She proved them wrong by ruling based on evidence, not emotion. She convicted defendants when the evidence warranted it and acquitted them when it didn't. She held officers accountable when they lied and credited them when they testified truthfully. Her experience made her better at her job, not worse. She could spot inconsistencies in police reports that other judges missed. She asked questions that revealed whether an officer truly had probable cause or was justifying a hunch. Defense attorneys requested her courtroom. Prosecutors learned they needed solid cases, not just a badge and a story. 3 years after the traffic stop, a reporter asked Judge Sterling if she thought anything good had come from what happened to her. She considered the question carefully before answering. Good isn't the word I would use. Necessary, maybe. My case forced changes that should have happened decades ago. But those changes came at a cost to me and 43 other people who never should have been violated in the first place. We shouldn't need federal judges to be unlawfully arrested before the system takes these problems seriously. We shouldn't need viral videos and lawsuits and public outrage before basic constitutional rights are protected. The fact that we do tells you everything about how broken things were. The police department still exists. Officers still make traffic stops. Arrests still happen. But the culture shifted in ways both measurable and subtle. Officers know their body cameras are recording and will be reviewed. Supervisors know signing off on bad arrests will cost them their jobs. The community knows they can file complaints that will actually be investigated. None of it is perfect. Systems created over decades don't transform overnight. But the trajectory changed, and that matters. Brennan's appeal failed, as predicted. His conviction stands. His prison sentence is public record. Anyone searching his name finds the full story of what he did and what it cost him. That permanent stain is part of his punishment, a reminder that authority without accountability eventually destroys those who abuse it. Some officers learned from his example. Others resented it, viewing him as a scapegoat for systemic problems. Both reactions missed the point. Brennan wasn't a scapegoat. He was someone who violated rights repeatedly until he finally faced consequences. The system that enabled him for so long deserved scrutiny too, and it got that scrutiny through the lawsuit and reforms that followed. Judge Sterling still drives past the intersection where Brennan pulled her over. She doesn't avoid it or take alternate routes. That corner doesn't own her. She reclaimed it by refusing to let what happened there define her or limit her movements. Sometimes she thinks about that moment, the lights in her mirror, the sinking feeling in her stomach. Then she keeps driving, exactly where she needs to go. That gas station on Riverside Boulevard still operates. People fill up their tanks every day, unaware of the history that unfolded on that concrete. But for Judge Sterling, for Brennan, for Mendoza, for the 43 other victims whose names never made headlines, that intersection represents something permanent. It's a reminder that badges don't grant immunity from consequences, that cameras capture truth that reports can't hide, that justice delayed is still justice when it finally arrives. The system failed repeatedly before it worked. Complaints ignored, patterns dismissed, violations rewarded with promotions instead of punishment. It took a federal judge being handcuffed at a fuel pump before anyone with power decided enough was enough. That reality should disturb everyone watching this, because it means countless others suffered without remedy, without witness, without the platform to force change. Real accountability isn't one verdict or one settlement. It's cultural transformation that makes these violations unthinkable instead of routine. Now, watching footage like this, it can really stick with you, right? Some of these clips stay in your head, especially late at night when you're trying to fall asleep. And speaking of sleep, a lot of you have told me you're waking up at 2 or 3 a.m. and just lying there. Can't shut your mind off. And the next day you're dragging through everything. I came across a simple 21-day sleep guide that's helped thousands of people fix exactly that. No pills, no apps, no gadgets. Just a step-by-step plan that actually works. It's only $15. I put the link in the description if you want to check it out. All right, I'll catch you in the next one.